Section 4. Unit 4, California State and Local Programs. Lesson 1, California Fair Lending Regulations. Lesson 2, California's Residential Mortgage Lending Act, CRMLA. Lesson 3, Usury Laws in California. Lesson 4, California Real Property Loan Law. Lesson 5, California Seller Financing Disclosure Law. Lesson 6, California Home Buying Assistance Programs. CalVIT and CalHFA Mortgage Assistance Programs. California offers two excellent financing options for home buyers. These are the CalVIT program and the CalHFA program. CalVIT. If you work with a buyer who is a veteran, you should make your buyer aware of the opportunity to finance using a CalVIT home loan. CalVIT home loan products offer below-market interest rates with low or no down payment requirements. Most veterans or active military personnel who live in California are eligible. CalVIT is a state agency that provides a variety of veteran programs, including home loan benefits to veterans and their families. While it provides these benefits to essentially the same audience as the federal VA Loan Guarantee Program, CalVIT operates in a slightly different way. The federal VA loan is funded by a lender that receives a guarantee of payment from the VA should the borrower default on the loan. In contrast, CalVIT actually acts as the lender and the seller. Sound weird? With a CalVIT loan, CalVIT holds legal title to the purchased property. In effect, the payments the veteran makes are to CalVIT as the owner/seller of the property, rather than mortgage payments to a lender. The veteran holds equitable title to the property until the loan is paid off. The CalVIT Home Loan Program offers low interest rates. A 3.75% fixed rate is available for eligible veterans. Low costs. Other than a 1% origination fee, there are no other lender fees, no underwriting, processing, or document fees. Manual underwriting. Each file is reviewed by a live underwriter, who approves make sense loans. California Home Financing Agency, CalHFA. The California Housing Finance Agency, CalHFA, finances mortgage loans to low and moderate income homebuyers. The agency, formerly known as CHFA, doesn't offer loan products directly to consumers, but instead through approved, private lenders. CalHFA loan products are typically priced at reduced, fixed interest rates and often include down payment assistance. Eligibility requirements apply for both the property and the borrower. The property must be located in California, be the buyer's primary residence, be a detached single-family residence, condo or attached unit in a planned unit development, be 5 acres or smaller, and be priced at or less than the allowable price limit, which varies by county. The borrower must have an income within designated limits. Be a U.S. citizen, permanent resident, or qualified alien. Reside in the home for the length of the loan, e.g., until refinanced or sold. Complete a CalHFA home buying education course. Satisfy underwriting requirements. Borrowers who use the CalHFA down payment program must also be first-time home buyers. California's Seller Financing Disclosure Law. This is a law that mirrors the spirit of the Federal Truth in Lending Act, but at the state level. If you're working with a residential transaction, for the usual 1 to 4 units, and the seller is financing the loan, you'll want to know the requirements that this law stipulates for disclosure. The purpose is to ensure that all parties are appropriately educated about loan terms and who is being compensated, and to create disclosure requirements when other disclosure laws don't apply to the loan in a residential transaction. Here's how it works. If you, as a real estate broker, are also acting as the mortgage loan originator in a seller carryback, where the seller carries back the loan on the buyer's behalf through a promissory note secured by a deed of trust, you are responsible for ensuring that the proper disclosures are provided to the buyer from the seller and to the seller from the buyer. These disclosures must be provided as soon as possible before the execution of any note or security document. The broker, the seller, and the buyer must all sign and receive copies of the disclosure statement. If you are not acting as the mortgage loan originator in this case, then it's not your responsibility to ensure that these disclosures are made. It's always the responsibility of the arranger of credit. What is an arranger of credit? If you help the parties with the finance paperwork and receive a fee for doing so, it's you. Here are some other specifics about the Seller Financing Disclosure Law. It's also known as the Residential Purchase Money Loan Disclosure Law. Transactions that are already covered by similar disclosure laws, such as TILA or RESPA, are exempt. The disclosures under this law are required when the seller is extending credit to the buyer and anyone other than the buyer or seller. For example, the real estate broker negotiates the credit agreement, prepares paperwork for the loan, or is paid in any way to arrange financing. Exemptions are made for attorneys representing either party and for escrow agents. Disclosure is required when the seller finances any part of the purchase on behalf of the buyer for properties with 4 units or fewer, when credit arrangements have a finance charge and include 3 or more payments, and when a credit arranger serves the parties in the transaction. Items required to be disclosed include the terms of the note, security instrument used, encumbrances that apply in their terms, balloon payment information, if applicable, and documentation showing that the buyer's creditworthiness has been verified. California Mortgage Loan Broker Law of many names. When a real estate licensee negotiates a loan for a buyer in return for compensation, that licensee is acting as a mortgage loan broker, also called a mortgage loan originator. Is this illegal? Not necessarily. If you have a real estate broker license in California, you can also earn an endorsement that licenses you to act as a mortgage loan originator, MLO. Licensing requirements fall within the Federal SAFE Act. The California law that regulates the activities of real estate brokers acting as mortgage loan brokers/MLOs is called the Mortgage Loan Broker Law, or the Real Property Loan Law. It was enacted to curb a variety of abuses, such as exorbitant commissions, inflated costs and expenses, short-term loans with large balloon payments, and misrepresentations or concealments of material facts. One requirement of this law is that, when acting as an MLO, the licensee must give the borrower a disclosure statement called the Mortgage Loan Disclosure Statement. This informs the borrower about the terms of the loan being offered. The licensee must deliver this disclosure to the prospective borrower within 3 business days of receiving the borrower's loan application. The borrower must sign the form to be obligated to its terms. The law also imposes limits on the amount of commission that the licensee can charge for negotiating a loan, as well as limits on the fees that can be charged in addition to the commission. In California, 2 agencies regulate the activities of mortgage loan originators. California Department of Corporations, MLOs licensed under this agency can negotiate loans only with lenders licensed by the California Finance Lenders Law. California Department of Real Estate, MLOs licensed under DRE can work with all banks, credit unions, and lenders in general. This particular state law for MLOs may be referred to by many names, so you might as well commit all of them to memory. This law is alternately called the Mortgage Loan Broker Law, the Necessitous Borrower Act, the Real Property Loan Law, and Article 7 of the Real Estate Law. Usury laws in California real estate. Usury is lending money at an excessively high rate, think loan sharks, but with business cards. Usury often involved unscrupulous lenders who took advantage of a consumer's naivety or circumstances to get them to sign loans with not just unfavorable, but nearly impossible, terms. Usury laws are enacted to prevent this practice and protect consumers. California has usury laws in place, prohibiting interest rates above 10%, but federal law effectively limits these laws to private lenders. Exemptions also apply to loans that are secured by real property and arranged for by a real estate broker. In Bach v. California Capital Loans Incorporated, 2013, for instance, the court found that, although the interest rate charged was excessive, 15%, and above California's usury law limit, it did not violate usury law. The broker who arranged the loan was the sole shareholder of California Capital Loans Incorporated, at the time the loan was made. The California Residential Mortgage Lending Act. The California Residential Mortgage Lending Act, CRMLA, was created to provide mortgage bankers with their own licensing law. Why would mortgage bankers need their own law? Because existing laws licensed mortgage brokers and lenders under the Real Estate Law or the California Finance Lenders Law, but mortgage bankers were left out of those licensing requirements. The CRMLA was created to regulate the mortgage banker's primary functions of making and servicing residential mortgage loans. An applicant under the CRMLA may obtain a license as a lender, a servicer, or both. CRMLA licensing applies to those that make federally related mortgage loans, those that make loans to finance the construction of a home, those that sell the loans to institutional investors, and those that service loans. Licensing authorizes them to buy and sell federally related mortgage loans and to provide contract underwriting services for institutional lenders. Licensees may service any federally related mortgage loan, regardless of whether they make the loan or buy the loan through a servicing portfolio. A licensed CRMLA lender is also authorized to provide brokerage services to a borrower by attempting to obtain a mortgage loan on behalf of the borrower from an institutional lender. Employees who engage in brokering activities on behalf of the CRMLA licensee must be licensed mortgage loan originators. In case you're fuzzy on the difference between a mortgage banker, a mortgage broker, and a mortgage loan originator, don't worry, because you're not alone. A mortgage banker is a primary lender that funds residential loans and may also service residential loans. The mortgage loan broker, MLB, and mortgage loan originator, MLO, have become synonymous since passage of the SAFE Act, which requires loan originators to be licensed. The MLB/MLO matches consumers with loans, takes loan applications, and processes them to the funding stage. A real estate licensee in California can apply for an MLO endorsement, allowing that licensee to function as a licensed MLO. California legislation prohibiting financial discrimination, Unruh and Holden. Although it might seem like it, not every piece of legislation protecting homeowners arose from the subprime mortgage market crisis. Two pieces of California legislation, the Unruh Act and the Holden Act, targeted discriminatory behavior and were enacted in 1959 and 1977, respectively. 1959 Unruh Civil Rights Act. In 1959, civil rights activists helped pass the Fair Employment Practices Act, FEPA. During the same time, California's Public Accommodation Statute of 1897 was revised and amended to become the Unruh Civil Rights Act. FEPA banned employment discrimination on the basis of race, religious creed, color, national origin, and ancestry. Because most fair housing laws have been based on fair employment law, this was an important development in fair housing legislation, as well. The Unruh Civil Rights Act, California Civil Code Section 51, prohibits arbitrary discrimination by businesses that offer services to the public. This includes housing, public accommodations, and, of course, lending. Licensees are bound by this act, as are any settlement service providers assisting their clients. The act reads, "All persons within the jurisdiction of this state are free and equal, and no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, or sexual orientation are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever." While the Act lists specific protected classes, court rulings interpreted this list as illustrative rather than restrictive. This means that the Act effectively prohibits all arbitrary and intentional discrimination by a business establishment. Holden Act/Housing Financial Discrimination Act of 1977. The Housing Financial Discrimination Act of 1977, Holden Act, made it illegal for lenders to consider the racial, ethnic, religious, or national origin composition of a neighborhood when making credit granting decisions. The idea behind the legislation was to slow the decline in inner cities by making more money available to urban applicants. The act required lenders to make loans if buyers were financially able to buy property, regardless of the area in which the property was located. As you may remember, historically, some lenders avoided these loans by redlining, which is refusing to lend in areas identified as minority neighborhoods. Nearly all loans for residential dwellings of 1 to 4 units are covered by this legislation, and licensees should ensure that any buyers they work with receive a fair lending notice disclosure. The Form RE 867 from DRE meets the requirements of this disclosure.